back on the record in the Gregory Martin matter, 24PR000777. All parties are back. President Court before me. We are ready to move to closing arguments. We'll begin with you, Ms. Salisbury.
Thank you, Your Honor. So we were here today and started this petition back in April of this year for the purpose of establishing an indefinite guardianship and conservatorship for Mr. Martin. There are a few things that you look at when you're looking at what's required for guardianship and conservatorship.
So I'm just going to pause. Generally speaking, I'm going to have
I can stand like
Attorney General stand when they're in court giving arguments. Thank you.
Sorry, my nose has been going crazy, so I'm just.
Oh, I'm sorry. Are you not feeling well?
Not particularly, but that's okay.
You can sit if that's the case. I didn't realize that.
No, it's okay.
It's up to you. Okay, go
We're all good. So there's a couple elements that we look at with a guardianship and conservatorship. The first being whether or not they lack capacity. It was eventually stipulated among here in the courtroom that he did lack capacity, so we look for the court to agree that that stipulation is that he doesn't have capacity. The second one that we look at is whether least restrictive means are existing. And so in regards to the guardianship, the supposed power of attorney that's being relied upon does not include any language with regard to medical decisions. Therefore, we're asking the court to find that a guardianship is necessary as least restrictive means do not exist. The next part of it is about the conservatorship, and there was a power of attorney submitted as OWK, and we would argue that while there was at one point in 1993 a power of attorney, it's been revoked by two subsequent powers of attorney executed significantly past that date. Additionally, Mr. Martin wrote in the Advanced Healthcare Directive that he did not want his children to make decisions for him. It was testified to by Luca Gorman that when he asked if he had anybody, or Mr. Martin had anybody to help him with decisions, he said no, that he didn't want his family involved. And then here today we heard that Mr. Rudolph had an opportunity to speak with him, and he also said he did not want Mr. Waleed involved in any
So let me stop you on that piece. The protected person is not here to testify, so I'm taking that information from Mr. Rudolph to be FYI information for the court. The court does have general responsibility for the health and welfare of Mr. Rudolph's client, and that was the context within which I took that information.
Sure.
I'm not taking, unless you can point to something that I'm missing statutorily that I should be taking that as information for the truth of the matter asserted. I just want to be clear that I'm not taking it for the truth of the matter asserted.
That's fine.
Am I missing something?
Nothing, no, sir.
Okay, all right, go ahead.
I think we can also say that from the testimony that's been provided, there's a pretty good amount of family strife that exists. And our position would be is that to allow Mr. Waleed to serve as a power of attorney would in fact be a large disservice to Mr. Martin because he's stated an intent to take him away from the family and the community that's here. And based upon the way that they've communicated, potentially interfere with those relationships that he has with his children that are here. With regard to suitability, Mr. Waleed stated that he couldn't be a power of attorney because he doesn't qualify, which is why he had filed to be the personal representative of the estate. The people that were named in the subsequent powers of attorney are choosing to not act. For example, Ms. Brethauer's choosing to not act. Ms. Wilkes has a founded elder abuse claim against her by Adult Protective Services with regard to Mr. Martin's finances. However, my clients have come in as third parties. They've come in at the request of Adult Protective Services and the VA. And Ms. Fuller has disclosed and has, in all of her cases, including this one, in her professional fiduciary disclosures, which are required to be filed with the petition, she's always disclosed her removal in the Lane County case. That's been something that she's absolutely provided information about, as well as bankruptcy. It was from 20-some odd years ago. Comparable to other PFDs, I think everybody's seen hers is substantially in length and an explanation to really give the court an idea of what's changed since the Morningstar case in 2018 to now. She's continued to be appointed by Multnomah County judges, Lane County, Deschutes County, Douglas County, a variety of counties all over the state. The court visitor that we have is a long-term court visitor, certainly not brand new to this, and she recommends her appointment. And my client's willing to serve with if there's any other conditions that the court would like in order to make them feel more comfortable with the position. She's happy to serve with those, as she understands that it's an important relationship between the court and someone that's acting as a fiduciary. She's been honest and open and thorough about any of the conversations people have had to ask about the removal. And she's willing to and happy to help facilitate the relationships that Mr. Martin has with his children, with any of his children that would like to have a relationship with him. There's no intent to move him away from the family here, his community, his friends. There's no intent to do any of those things, but really to help him do better in where he's at. So today we're asking that the court find that Mr. Martin is incapacitated, that no least restrictive means exist, and that my clients are appropriate and to serve as the indefinite guardians and conservators for Mr. Martin.
Can I ask you a question? This is
Yes.
education for me. So the 1993 durable power of attorney that Mr. Lead has presented, let's just hypothetically, total hypothetical, if in fact the court found that was a valid durable power of attorney, what authority, if any, does the court have to disregard that and find that there's some other better suited situation? Is there any?
So, I'm going to ask that question. The court certainly has the authority to terminate all prior powers of attorney. And I believe the least restrictive means still comes down to whether or not the person who's acting is acting in the best interest of the protected person. And as we've heard quite a bit, there's a ginormous conflict of interest that exists because you cannot be on both sides of the lawsuit. And if you're representing the protected person, you can't also be the person that's suing them. And that power of attorney does talk about a conflict of interest, there being an actual conflict of interest. It is common in power of attorney processes that when you execute a new power of attorney, it revokes all prior powers of attorney. It's a common practice. In fact, when we do estate planning, often if we are doing two powers of attorney at the same time, let's say a medical and a financial, you specifically state in there is no intent to revoke the other, so you don't have a situation where they're revoking each other. So it's a very common practice, and in the powers of attorney that were done for specifically Ms. Bredhauer, it said, I hereby revoke all prior powers of attorney. So I think to find, the only way to have that not come into play is we would have to find that hers was invalid. And I don't believe there's been any evidence to establish that hers was an invalid power of attorney, since it would have revoked the prior. With that being said, I will say our Chapter 127 is not fully fleshed out on things when it comes to powers of attorney. But I do believe it's within the court's pretty broad generalized powers to do what's in the best interest of the protected person and to avoid conflicts with that person.
So doesn't let me ask you this question. I was looking at the 1993 power of attorney, and you rightfully pointed out two sections, I think, that say, hey, that Mr. Martin Sr. can revoke this at any time, should he so choose. But there also is another that Mr. Willie kept referring to, and I saw it, that says that this is irrevocable. How do I look at that?
I would argue that the drafting of it was not good, and that there are inconsistencies that exist inside the document itself, which often when we have those types of situations, we bring them to court, and unfortunately the only person who has capacity to really even be able to discuss it is Mr. Waleed, and he'll present his position on it, and there's not a great option for the other side to present and say, hey, that's not how I understood it. I believe the document itself lacks meeting of the minds, because it seems to say things like here it's inconsistent, but in multiple other spots it's revocable or irrevocable, and there was no counsel involved in the drafting of it, the advising of it. In fact, we have inconsistent statements between the document itself and the testimony today to say who even wrote it. Nathaniel Martin has on there on every page, and then in the very beginning of it, it says it's written and drafted by him, yet we're getting testimony that it was drafted by Mr. Wally and Mr. Martin. So in general, I think it is voidable. I think it lacks meeting of the minds because it is inconsistent, and we could provide extrinsic evidence to discuss whether or not because if we outside of the four corners of the document, because the document itself establishes an inconsistency. But unfortunately, everybody who's been involved with it has either passed away or is incapacitated, with the exception of Mr. Waleed. And I think more importantly than that document is the statements that have been made by the protected person, and as a current, what does he want now? And when he said it to Mr. Gorman about he didn't want the family involved, he has it on the Advanced Healthcare Directive, he didn't want the family involved. He executed 2 other powers of attorney stating he didn't want, these are the people he was picking.
So, again, this is just educational
Sure, yeah.
for me, because I think what I'm understanding your argument to be is that even if the court hypothetically were to find that the 1993 power of attorney was valid, speaking hypothetical here, that it's the petitioner's position that because of the reasons you mentioned, conflict of interest, for example, being one of them, that the least restrictive means to appropriately care for the protected person at this point is your proposal, which is Ms. Fuller and her agency. Am I saying that right? Am I understanding it?
Yeah, it's to say that no least restricted means are existing or suitable at this time. Because if you're going to sue the protected person and you're supposed to represent the defense, and that's actually, in the document itself, it mentions conflict of interest. That makes it he's never going to really get a defense. And so, additionally, he did revoke them. So whether or not it's a valid power of attorney, it was revoked. And that means that and since no one who currently had a power of attorney either wants to serve or is suitable to serve, then that would make it so that there are no least restricted means available, and so the guardianship and conservatorship would be the alternative.
And then the power of attorney that Ms. Wilkes presented. Now, ultimately, we got to a place where Ms. Wilkes, when she started her case, she said, I want you to enforce power of attorney. I want to be the guardianship and conservator here. Midway through the case or so, Ms. Wilkes changed her mind and said, no, I'm not asking for that anymore. Correct, Ms. Wilkes? Rather, instead, you were supporting Mr. Waleed.
I shared with the court, as I recall, early on, that I wasn't here to be in position to be appointed for anything for Mr. Martin.
And ultimately, you were supporting Mr. Waleed's position as being correct?
Absolutely,
okay.
100%.
All right, so then we don't need to worry about whether or not how the court should view that particular power of attorney, because that's not being argued from Ms. Wilkes' position. So, okay, that's helpful. Anything else?
No, Your Honor.
All right, thank you, Mr. Rudolph.
Thank you, Your Honor. I think it's important for the court and the parties to understand how I view my role here as the court-appointed attorney for Gregory Martin. So Rule 1.14 of the Oregon Rules of Professional Conduct governs how an attorney is supposed to handle a situation where you have a client with diminished capacity. What it says is that you're supposed to, as far as reasonably practical or possible, have a normal attorney-client relationship. However, it goes on to say that when the lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm, unless action is taken, and cannot adequately act in the client's own interest, the lawyer may take reasonably necessary protective action, including consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, seeking the appointment of a guardian ad litem, conservator, or guardian. So I was appointed by this court. I had no prior relationship with Mr. Martin. And upon my appointment, I quickly learned that my client's ability to communicate was severely limited, and his ability to communicate really in any meaningful way regarding his financial matters, medical issues, was non-existent at the time that I was appointed. I had multiple meetings with him, and it wasn't until this last meeting that I was able to get a response from him that gave me a clear picture as to what he would want me likely to do in this scenario. So when I shared with the court what Mr. Martin had said to me, it was not, as Your Honor pointed out, to present evidence. It was to explain to the court and the parties why I am presenting the case that I'm presenting. So all I had to go on initially was my reasonable belief that my client was at significant risk of financial harm due to the substantiated abuse allegation against Ms. Wilkes and the claims that Mr. Waleed has asserted in this proceeding, which he later filed in federal court alleging $7.5 million in damages against his own father. It does appear that my client's ability to communicate is improving, and thankfully he was able to communicate to me that he doesn't trust Mr. Waleed and he doesn't want Mr. Waleed to be in charge of his money. I hope his condition continues to improve and we can learn more about what he wants, and we can keep the court apprised of those wants with respect to his medical and financial decisions. So turning to the legal issues before the court needs to consider, does Mr. Martin meet the standards for needing a guardian conservator? If so, are there any less restrictive alternatives? And if there are not less restrictive alternatives and a guardian conservator does need to be appointed, who does the court appoint? At this point, there is clear and convincing evidence that Mr. Martin meets the standards under ORS 125.005, 300, 305, and 400 that guardianship conservatorship is necessary, and he meets those standards of being incapacitated and financially incapable. So the next question is, do we have a less restrictive alternative? Primarily, those less restrictive alternatives would be a power of attorney for finances and a healthcare representative appointed under a Oregon Advanced Directive for medical decisions. Assuming that the powers of attorney that we've discussed and the healthcare representative nomination under the Advanced Directive were valid, they have not worked. If they had worked, then Mr. Martin wouldn't have languished in the hospital for 5 months. His health and safety are at risk. Your Honor, he needs a guardian. Unfortunately, his problems don't end with his medical issues. His financial well-being is also at risk. There's been evidence of 3 competing powers of attorney. There's been evidence of substantiated financial exploitation. There are claims pending by Mr. Waleed as plaintiff suing his father for $7.5 million, while Mr. Waleed is asserting that he can also be his father's power of attorney. A conservator is needed to take over management of Mr. Martin's assets and income, deal with things like Medicaid eligibility, taxes, bills, investigate financial exploitation, consider whether legal action is prudent and necessary to try to recover any of his assets, and most importantly, immediately deal with the claims that Mr. Waleed has filed. There's been at least 3 parties who have claimed they were agent under a power of attorney: Dawn Breathauer, Selena Wilkes, and Mr. Waleed. Both Ms. Breathauer and Ms. Wilkes have stated they do not want to serve. It's my submission to the court that Mr. Waleed is not qualified to serve in a fiduciary capacity. primarily, again, because he's suing his father, which would be a direct conflict of interest. So Mr. Martin needs a conservator. Next question is, who does the court appoint? In considering this, the court is guided by ORS 125-200, where the court looks at the preferences in appointing a fiduciary. Most importantly, we look at the stated desire of the respondent, Mr. Martin. Again, his legal position is that he doesn't trust his son, and he doesn't want him to manage his money. There's been testimony by Alzina Martin that Gregory Martin said that Mr. Waleed lied and took assets from him. Don Brethauer testified that Mr. Martin did not trust Mr. Waleed. So finally, we look at who does the court appoint. The court only has one party before it who has filed a petition. There's case law that states that the court can only appoint a party who has properly petitioned. So at this point...
Can you, on that point, two questions. First, can you point me to that case? Second, I believe when we started this case, we discussed that issue with respect to the responses and counterclaims, etc., filed by Mr. Waleed, that what he was also, it was taken to, everyone was on notice that in fact he was asking to be appointed to be guardianship. I think then later it got a little murky because I think maybe you said you weren't doing that. We're going to get to your closing argument in a second, but I'm going to go back to the first question. Do you have that case you mentioned, Mr. Widow?
I can find that.
Okay, and you can look for it later while the others are giving their closings, but I'd like if you find it then.
I can definitely find that.
Okay, and then what's your recollection of Mr. Again, I know when we started this case, I believe I was setting the stage and I was interpreting the responses by Mr. Waleed to be a counterclaim request, or cross petition, if you will, requesting that he be appointed the guardian. So let me just, before I have you argue, let me ask you, Mr. Waleed, I know then maybe you changed your mind, I'm not sure. Mr. Waleed, are you still asking that the court appoint you guardian in this case? Or are you simply saying, are you simply going to be arguing, I want you to uphold the 1993 general power of attorney, and even if you didn't do that, Ms. Fuller's not the one, she's not suited. Am I missing something?
No, that's kind of where I would be going.
Okay, so you're not arguing that you should be appointed to be the guardian, like there. In other words, does that make sense?
It's too restrictive, and when I petitioned the court, the commissioner of the probate department sent me the information for the personal representative. It's like here, this is what you need. And so I filled that out and proceeded with that, paid my fee for it, and then was told later that, hey, you can't be the PR because he's not dead yet. And my whole basis of all of this, after I can speak, was really based off of the original power of attorney, durable, that was nominated by my father. And because these third parties came in and intervened instead of letting the natural process informing me of his incapacitation, they didn't do that. And so
I think you're going to get there. I think we're on the same page, which is you're asking me to uphold the power of attorney, that's the least restrictive means. It's in your dad's best interest at this point. You're not, it's a little bit splitting hairs, that's why it's a little confusing. What you're not asking is that you cross-petitioning to be the guardian, which is different than me upholding your power of attorney.
Yes.
Does that make sense?
Yes, it does. And it's only became that way because during the second hearing on May 23rd in front of Judge Henry, he asked the question, is there anybody in here petitioning to be, is there another guardian, conservator? And so I moved in that direction. And then when I submitted the documents, it was sent back from the probate commissioner stating that this is more suitable for what you are trying to do. And I didn't know the difference between heads or tails. I just pursued the PR because I believe everyone thought my father wasn't going to make it. So I didn't know that he had to be, So
I'm still kind of going back to the question of, and thank you for indulging me because I haven't got to your part yet. This just helps me put everything together. I'm waiting for a case that Mr. Rudolph is going to cite to me, which essentially what he's saying is that case is going to tell me the only choice you have is Ms. Fuller right now. You can say yes or no to her. I can't make somebody up.
Yeah, as far as.
But I could find that it's
conservative.
not her. I could say, well, we're not going to do her because I think there's a least restrictive means, which is this 1993 POA, which is what you want me to do.
Gotcha.
Okay, so, but you're not asking me to say, okay, you're not petitioning to be the guardian.
No, I'm not.
Okay, all right, thank you. Mr. Rudolph, did you have that case?
Yes, Your Honor. It's Spady v. Hawkins,
You spelled Spady.
Spady v. Hawkins, Hawkins, and that's 155 ORAP 454.
155 ORAP.
454.
Spady versus Hawkins, 155 ORAP 454.
Correct.
All right, thank you. And so, I realize we took a detour there, but that's helpful. Anything further, Mr.? You can continue, Mr. Rudolph.
Yes, thank you, Your Honor. So, in order to protect my client's interests, Your Honor, I do believe the appointment of a guardianship conservatorship is necessary at this time. And I think given all the facts and circumstances that you've heard, the only reasonable option is for the court to appoint Ms. Fuller and Ms. Fosbach at this point. Now, I want to also deal with some of the questions you were asking Ms. Salisbury. So you asked what authority the court would have over Mr. Martin's financial affairs with respect to the power of attorney. So under ORS 125.0257.
ORS 1250.
It's 025 subsection 7.
Okay.
That gives the court authority, court has broad authority over a protected person's affairs, but specifically, if the court finds that a conservator should be appointed, the court may exercise all the powers over the estate and affairs of the protected person that the protected person could exercise if present and not under disability, except the power to make a will. So that very, very broadly gives the court authority to do anything Mr. Martin can do. And under subsection 8, the court can do that either directly or through a conservator. With respect to the power of attorney document, the 1993 document, this document states in numerous sections that it is revocable, and Your Honor is correct in that it also states in certain sections that it is not revocable. It does state clearly on page 2 that this durable power of attorney shall become irrevocable and effective upon, during, and after the disability or incapacity of the principal. So, up until the time that it became irrevocable, which would have been triggered by Mr. Martin's incapacity, he would have authority to revoke it, which he did in several subsequent documents. I would also submit to the court that, frankly, this power of attorney, the validity should be questioned. It's a bizarre document that states in some sections that the power is given to the agent to act for the benefit of the principal. It also states in one section that the power is not held for Mr. Martin's benefit, which I don't understand. And I don't know how anybody could explain it to me to make me understand. It does state that it was created, drafted, dated, and acknowledged by Nathaniel Garland, who is deceased and is not here to testify about what this document means. And I think, given the circumstances, we could certainly go outside of the document, inquire into extrinsic evidence to try to determine what it's supposed to mean. But it's contradictory on its face. So at this point, I'm unfortunately asking that a guardian conservator be appointed for Mr. Martin, and I think the court, the only reasonable option before the court is to appoint Ms. Fuller and Ms. Losbeck. Thank you.
Okay, thank you, Mr. Ruff. All right, Mr. Waleed?
Yes, thank you. In this closing statement, we've heard a lot about what people don't understand, and different lawyers have different levels of knowledge and understanding. And it's clear to me from reading the durable power of attorney on page number 6 that it says, I am to have access to my father's health care, medical records, and statements regarding billing, insurance, and payments. That's number 17. On page number 6, they're stating that there's nothing about medical in here. There it is right there on 17. And also, when we get to the Martin family agreement, I just want to go there, the irrevocability of certain powers, is because it's connected to a pledge agreement where my father pledged his property. I pledged my labor to work for my father for a set period of time, and I would keep the receipts on an annual basis, and we would ante up the receipts and know the balance as long as my father kept a tidy house with respect to there's no liens on the property, there are no bills or anyone have liens against him. And because it's invested, I want to read this part. Says the principal giver of this durable power of attorney has relinquished the right to control, and the power is not held for his benefit. This durable power of attorney is revocable. It is clearly stated it is not revocable by the principal if it is coupled with a vested interest, if it is given for consideration or as a security. We're talking about securities law here. So my father was specific and understood this, that he couldn't, if I didn't uphold my end of the deal and work for him, that it could become revocable. But as long as I did my part for 33 years, showing the 51,500 hours that was given to Montana, Oregon, that was my 30-year collective history, that I have no payment from my father because the payment was the property. That was our deal. There is no mixing it up. It was straight up. We agreed to this deal. I honored that deal for 33 years. My father becomes incapacitated, and so part of that rule was it's a springing into action. So when he signed that, he didn't want me to have nothing to do with anything else other than the deal that we had. As long as I upheld working for him, keeping the invoices together, there was nothing else to talk about other than he had a plan, we had a plan to put everything together, and so that way the transfer of the property would be an easy process. I would have already had it's not an inheritance, what I've earned from my father. My father is no cheat person. He's not going to cheat you or beat you, especially when you honored him. I did more than that. I honored for our trade. I became the same electrician that my father is. He's a master. I'm a master. I became more involved into banking, into tax. I have a banker's license, American Bankers Association. I'm a private banker. I'm an IRS current tax professional license. And I'm a Montana or remote online notary. I can sign notaries anywhere in the world online, as long as it pertains to the United States.
One question for you,
Yes.
Mr. Willie, before I forget, because
Sure,
it's on the topic you just mentioned, which is what I'm hearing from you is, hey, I entered into this deal with my dad. And the deal was, I'll do a bunch of work for him for a long period of time, and eventually my dad's going to pay me back with this property. Am I understanding you at a high level?
Yes, that's
Okay. And as part of that, he writes that there's this durable power of attorney, which you're asking the court to consider, written in 1993, which says, hey, when I become incapacitated, then my son, he can take over. Until then, I'm doing my own thing, because that's just your dad's personality. Don't want people in his business, right?
Correct.
So then, if you're, here's the question I have for you. What if he never became incapacitated and just died in his sleep? Does that mean you're out? According to your argument, 30 years of work?
No, because I have the pledge agreement, the UCC agreement, and the pledge agreement and the promissory note.
And that's all part of Exhibit K.
It's in there because they were all together, meaning that.
And so, and I haven't determined what parts the court can, other than the
durable power of attorney.
But I haven't determined whether or not the court can consider the other things in there.
Yeah.
The court will consider what the evidence rules allow. But okay, I think you understood my question, which is, what if he's never incapacitated, dies in his sleep, you work for him for 30 years, you're left holding the bag.
Yeah.
What happens then?
I have proof of my hours worked that was signed and notarized by him, and the agreement, the pledge agreement, the promissory note, and the UCC, Uniform Commercial Code security agreement. So that was separate from the durable power of
So
attorney.
you feel like that's how you were protected if you didn't become incapacitated?
I have the invoices and the work hours to prove it, and I can prove my dad never paid me. But our deal was father to son. Hey man, I need some help. I need you to work for me. In the end, you'll be able to get the property and the assets. And while you're working for me, I don't have to spend any of that money paying you. I got to keep the 2511 Northeast 8th house to live in. That was a simple deal when it started. And I had created other businesses over the years and eventually moved to Montana. And I already had these hours invested in the bank. It's like an apprenticeship program. I was already apprenticed, went to a journeyman, went to a master's. I was licensed in Washington, Oregon, and Montana all simultaneously. I did all the work for my father. But the durable power of attorney was really just specific if he became incapacitated, meaning his concern was me being in his business, telling him what to do, and I couldn't do that. He could pick Selena, he could pick anybody to be his power of attorney while I was present. Mine was only special with respect to when he became incapacitated, he did trust nobody else. That I would follow through and do the things that I've shown him over the last 33 years. I'll be on time for work, I'll do all the projects, I'll bid the work, I'll even do the taxes. I was one central part of my father's business, and that was it. He became incapacitated, and people started eating on him. And I don't want to go too far with this. I want to get into the case, but since we were talking about this durable power of attorney, it was really about it being irrevocable because of the invested security interest with the lien, the promissory note, and because of that, and when you go look up this particular power of attorney law in there's some of the other books, as I had to look at it to understand it, and I really didn't get it until 2019 when my father came to Montana and he bought the books and he bought the copy of that. The originals belonged to my father and to my uncle. I never got an original anything. But when I got this information in 2019, my father disappeared. I didn't see him. I was calling. He was incapacitated then. But I had no proof, and I had to be patient and continue to. I stopped really doing the work because he lost his license in 2020. And that was pretty much hearsay. He was over here. Luca got a property. And so I was kind of shook up for a moment, but I had to be patient because I didn't have all the facts. And it wasn't until I called December 13th, 2023, checking on my father. I reported his kidnapping, his missing, everything I was hearing from my sisters. I contacted Earl. No one contacted me. So I came down a few times. I heard he was staying with the girlfriend, etc. So it wasn't until 23 of December that I called Adult Protective Services and I made the report. I gave her a copy of the durable power of attorney that if he's incapacitated, I come in and take over. And he was only being sued by me because he breached the contract. Now, and the third-party people came in and claimed a guardianship and conservatorship, bypassing our already 33-year-old agreement that I've already upheld. So it was really simple. I moved to Montana because I have a family, and my father had Oregon here, and he told me at one time Oregon was too small for him and me. I was already moving there, but that was my dad's attitude, okay? But he would never shuck or jive about a deal. But if you went to sleep and I didn't follow up and come to court and petition against them and object and go on this process and then file the federal claims because I'm looking out for my father's interests, they can't. They're third-party people. They don't know the agreement that we already had and upheld, signed by, witnessed by his mother, Uncle Ed, Uncle Nathan, and Uncle Clinton. There's my third uncle here. And they live in Iowa except for Uncle Ed. We have my Uncle Milton. I call him Gary though. So this was all done with respect to planning, our estate plan. So my uncle told us, you two work together, you'll have some money in the end, and when you get old, your son will be there to take care of you, and you get to watch him do everything that you need done. My father didn't pay me. He owes me. So this was already a part of my payment. I just had to wait to file into the court when I seen the third party came and interfered with our existing contract. And so we already have an established agreement. We've already worked it out. I've already did the work. My father lost his mental capacity, and no one can take care of my father like I can. He's just that kind of person. He's lovable, he's kind. He doesn't want to be sitting up there where he's at right now. But as far as his being health, it's a place that he needed to start versus sitting in the hospital for 6 months because some unethical stuff done by the guardian and conservator and attorney. So I'm still going to call that. Me and my father's rights, 14th Amendment due process rights were violated. They went past me, didn't call me, didn't do anything. They just made a decision and filed with the court. And then, of course, I've mentioned all the things about this. And one was that Mrs. Fuller, in 2024, in February, 2 months, she did not include that in her petition that she was found unsuitable. It's nowhere in the petition. We have times where it was held back. So we're thinking of this 2016 issue with Morningstar. She has a 2024 issue that Mr. Stinson brought about Judge Norby in Holland saying that she's unsuitable. And so somehow all this got past the court, and this petition got moved under the idea that he was incapacitated. Then we had two other parties who were supposed to be taking care of my father. They never responded to me. I sent them letters. I did a lot of different things to communicate with them for over a year and a half. So when I made the phone call from what I had to Adult Protective Services, it was to the point. Hey, where's my dad? And she never got back to me. She just went about her business and called her friends out of Eugene to become a durable power of attorney. And as we could hear from earlier testimony that Mrs. Salisbury, the attorney, was making all these moves so that way we never were possibly served according to 121.125.060. Me being his durable power of attorney and my father, we've got an affidavit where my father wasn't even at the hospital. He wasn't in this room that the affidavit states. The description of my father is not clear, and this particular gentleman by the Kyle Berg of Peter Pan Delivers does not want to accept a subpoena, yet alone to come here to say this. You know, I did go to the room, and this isn't the guy. He's running, and we have evidence that Mrs. Falsback wasn't there on the 23rd either when she was on the stand. So, I mean, we have things that by the rules just weren't followed. And they're expecting, you know, me to give up my rights. I'm fighting for my father. My father would be proud of me. You done came down here and you battled against something that went against me? Yeah, Dad, it's the way you raised me. Don't give up. Don't quit. And so we've had all these things that have happened. My father intended for me to take care of him. And he's only being sued by me because I have other people that have control of him. So if I don't sue him to get to what it is that we agreed to do, then I would be letting them go away with what me and my father planned to share together in the end. He's not going to be here long. And so they've already wasted 6-8 months of my father's life and my time. He's already been missing for 3 years anyway. So we have a relationship. All this of he doesn't trust. That's my sisters. There's been jealousy with them and my father for years about me. I'm the only son. I'm the only one that's worked with my father and did the things that he did. I was the only one a part of the family business. No one else was. No one else can claim it in the family. No one has an electrical license. They didn't do anything. This is me and my father's. This is our real work. This is authentic. This is what he planned. I just put it together so that the court could have it. But along with the affidavits of work that he signed and notarized in front of a notary, both of us, about my electrical work experience. That's one trade that you have to have your supervisor, which has been my father, sign for my license and state that he worked 18,000 hours. He worked a total of 51,500 hours from 1985 to 2019. And it's all on the affidavit original forms of Montana State, Washington State, and Oregon State. And then the affidavits or the invoices that I had to keep according to our agreement, because when Uncle Nathan passed away, it was still business with me and my dad. We never had that issue. I just had enough sense to not demand from my father what it is. You had to work that out. Like, we're going to sit here and argue about this. I didn't put my time in. He knows it. I've signed the hours. There's no question. He just wanted to get to a better place, and he ran out of time. So that's why these people are involved, Fuller and Mr. Rudolph. And so they can come up with different reasons why, but it's solid evidence before the court that, hey, we had a deal. This is the original agreement. I know my father's signature. I've seen stuff on my sisters. That was not my father's signature. Me and my father were very careful about what we signed. And there's signatures on other power of attorneys that's upside down and crooked. And that's not my father's. My father has a special way he does his G. I can't even duplicate it. And I used to be called Gregory John Martin's Peter too. So I wrote mine. Don't look nothing like his. So I'm just want to state that we have Oregon Advocates LLC that has been recently told, that's what Mr. Stington was here today, he wrote that letter, that they're unsuitable. And it was not mentioned in the petition before the court. This is 2016, and Fuller's already been in trouble before for not disclosing information. Why would you leave out, if you signed the petition April 18th, which just happens to be my birthday, that you would just put off the case as being told you were unsuitable and that you did not deserve a permanent guardianship because you are only temporary capable. And it was not in the petition to the court. So we have some things that were just misstatements and some not just errors, but they're trying to attack the viability of what me and my father planned. Now, if I didn't work all these years and didn't do what I did, I probably wouldn't be here. I'm here for me and I'm here for my father because this was his plan. His mama signed it. His brother signed it. And they were happy that we actually engaged into an agreement so they could see one part of the family. We would vote that out of anybody that could be successful in the construction trades is Greg Sr. and Greg Jr. You two have each other. My uncle's kids, they didn't. Uncle Paul, he died. He was an alcoholic. Uncle Nathan's kids. Uncle Ed's kid was involved in the drugs. Elliot, he was at the family Father's Day. That was our last time together. And I was called into the room to talk about it, and we had to go draft the documents. When I say we had to type it up, my uncle was the mastermind, but he made me and my father do our work, and he told me, you better stay on top of your father, because he's the type of person that doesn't follow through. And so that was given to me from day one, and I liked working for my father. And to know that in 20 years from now, that I would have not only access to the property, I was giving my father money for my yearly work. I was probably $200,000 a year. I was eating up all the projects. Earl to testify. I was just on the job. I loved my work, but I also wasn't getting paid. So I had to find a way to create other businesses, that would offset. And so I had income, et cetera, et cetera. But he did pay for my child supports. It came out of there. That was a deduction, $114,000 for Delcina, $120,000 for Nicholas. And they were paid like clockwork because my father wasn't broke. Okay? He really wasn't. He just spent his money different. He was a cash method person. I just tried to stay on him about getting receipts and reporting that, giving 1099 miscellaneouses and EDCs out so he can account for his money. But just back in what I need for the court to do is to honor. Just because my father got incapacitated and some third-party people pulled in, and that we see that they're really not honest. There's an integrity to this issue. I've been coming down from Montana. I have a family. I have a daughter, 16-year-old. Okay? I have a place. I have a business. But I've made sure that I came here before the court, that I filed and I petitioned for a guardianship, conservatorship, for a personal representative. And no, I'm not a lawyer. No, at all. But doesn't mean I'm done and won't do the research. And so this wasn't a quick overnight situation where I was just going to walk away and they thought I was. So I was not. I wanted here to stand for my father, and I filed complaints into the court. It is called an account stated. One of the cases. It's just me and my father, going to be ruled by the judge, and it's basically based off of our agreement, what we said we was going to do, and the federal court looked at that and said, hey, you guys are 50-50. But hold it. We can't have two things going on at once. So when this is over here, the court there can review if it decides to, but I have an account stated. It's basically my father agreed to everything. All the documents are there, and also all of the 600 projects that we worked on from 1985 to all the way to 2020. I've got every project, every permit, because I keep that data. I'm a CEO of a company I created 1997 called the Contractors Information Bureau. I started here in Oregon. My clients were Hoffman, Drake, Deakin, all the big companies. And then I also did things for the little Port of Portland protege companies. I was members of AGC. My father was too. So we have a huge construction thing. And also I created technology companies that the people who invested in Google wanted to buy into my company. I just wasn't ready for that type of investment at the time. I still have work to do. So today, I do more than what I've done. But I've honored that. I'm a great electrician because of my father, and I just was able to take it to a next level. So I do videos, all these other things of all my jobs, and they're assets, intangible assets, that I'm able to get credit for on my tax return. But me and my father, we were meant for each other. Okay? I can disagree, he can disagree with me, but sometimes when I see him now, my dad is crying for me in his eyes. Son, you keep leaving. He even said that. When you coming back for me? Dad, I'm coming. I got to take care of this, but I'm here for the court. But I don't go to my father and talk about what's happening here in the court. To me, it's unfair because he can't participate. So what I would like the court to do is to uphold our original agreement. It's less restrictive. It means what it means. If that can happen, yes, I'd automatically file the motion to dismiss my father from the case and go after the people who actually stole the property and who created damages. But if a third party has my father and the interest involved, well, I have to hold my father accountable for his breach of contract and selling the property, whether it was taken from him from a fictitious way or fraudulently. I can prove that. But that's the only reason you would say there's a conflict of interest, because they took my father from me and interfered with our agreement. So if I sat around and did nothing, acquiescence is silence. So I'm not going to sit around. I put my energy and my time and my effort, and they're legitimate claims against all of the parties. So I need the court to uphold our original agreement and to terminate the temporary guardianship of Fuller, Oregon Advocates, and Fallback, because it wasn't done correctly. Had they talked, they would have probably been a different situation. Because I knew at the time, hey, I didn't have all of the knowledge of what I was going to do in the beginning. But now I know what needs to be done. So the issues here about this original durable power of attorney, I was never my father's power of attorney. When he signed it, I wasn't his power of attorney. It only became active in 2024 of March, not some other time that Mr. Rudolph had spoke about. When Dawn signed her power of attorney, I was not power of attorney. That's why I couldn't move from Montana. But when he became incapacitated, and I didn't get any return calls from Adult Protective Services, and I made the report, and then they hired third parties to come in, hey, that showed me that this wasn't fair. And then you add the hiding and meeting in secrecy and all of them as a group, meeting and talking to judges, and then there is a Oregon Rules of Professional Conduct, and it's called 8.3, Reporting Professional Misconduct. Regardless if someone doesn't like it, there are rules to being an attorney, like there is rules to being an electrician. Okay, you have to do certain things right, and if I burn down a building and someone was harmed, and they find out that I didn't ground certain equipment, I could be in jail. And there are electricians on death row, because we uphold the license. And it's the same to me with an attorney. You have certain rules you're supposed to follow. And so when you bend those rules and you withhold information from the court that, hey, I was found unsuitable in February 2024, and it's not in your 2 months later, you held that information back but only want to talk about it 2016, that's an ethical issue. That's not being fair and honest with the court. And then being out of business, there's an effect of a dissolution, ORS 63637. And it means that when you're out of business, you're supposed to be just winding up the business. And I think 6 months of your license being expired and you're out petitioning in Clackamas County, Lane County, and your license is expired for failure to file an annual report, and then you know that and still want to move forward, that's a level of disagreeable, ethical, and I think fraudulent, because it was never mentioned. Oh, we got a license fixed last week on the 18th when we filed. It was out of business. We've updated that. They went on like nothing never happened. So I'm just asking the court to put everything in perspective. They could have did much better. My father didn't need to sit up there for 6 months. They just refused and ignored me like I have no rights, or my father has no rights. And this is why we fought back, to protect our family interests, me and my father's. So when this is decided, the court rules that, hey, we're going to uphold the less restrictive part, that Mr. Martin be allowed to, if we want to go to Montana when it's time. Right now, my father needs to heal right now. I mean, really, I'd be thinking February, April, it's not April, but January, February. I would love to take him home for Christmas now. So that way he can be around his favorite granddaughter. We've seen from the court today that my sisters do not speak to my father. He has no friends. His only friends were these two who he trusted to be power of attorneys. They didn't ask to. He signed some documents and gave it to them. So I've been paying close attention to them. Some of the stuff I haven't found answers, like the bank statements, etc.
Yeah, let me ask you about that. So there's evidence in the record that there was $194,000 in your dad's account, and in a very short order, while your dad was incapacitated, it was down to $34,000, and it's during the time within which Ms. Wilkes and Mr. Wisdom were in charge of him. I'm a little unclear what your position is with respect to them. Are you telling me that the evidence shows that that's just being misread?
Right now, because I don't have access to my father's medical records, which would give me, I'm a researcher, I could see when, dates, and times, and the so-called bank statements, etc., the ones I received, she never sent a second copy that showed part 2 or the additional page missing.
Okay, so what I'm hearing from you right now is you don't have enough information, which means you haven't looked for the information, and so you haven't come to any conclusion yet on whether
No, I
there's
have
anything.
looked for the information, but I would have to subpoena that, and this was not the proceeding to do that in. I believe we were under the scope of who was going to be guardian conservator, but yes.
So it would be accurate to say you just haven't come to a conclusion.
I don't have the information.
Okay, all right, thank you. I was just
Okay, I'm just saying, no, I mean, I can't say someone's guilty when the courts, not the courts, you, but Adult Protective Services just now filed its NOSA report on October the 3rd when she was supposed to be here on the subpoena. So if they're wrong, and if they have harmed my father, they are included in the federal complaint for damages. They are. They can't get out of that until we find out the facts. There is no one. There were things that were done against my father with Rudolph, Salisbury, and Fuller. There were things that were done that were questionable. And racketeering fits the whole group. Everybody did something to my father. He has no property in his name or my name. So I'm going after for the truth. Because you see me with them. This was my father's friends. I have to treat them that way until I'm seen otherwise. You know what I mean? I mean, honestly, hey, I'm not happy. I look at it, it was crazy. Looking at the bank statements and going, what? You're hitting them up for 1,000 every day? 5,000, but it doesn't say withdraw indoors. You know, there's like something missing. It's like someone did a PDF file and erased certain pieces, so it's fragmented data. Because there is another court hearing that Mrs. Wilkes was involved in, and when I look at the bank statements from U.S. Bank, everything's filled in. Where the money was, how the checks were, money orders issued to, you know what I mean? It's a full record. This record that I got from Fuller, it's not complete to me, and it's not full. As you mentioned, she said she didn't include the other pages to that. And to me, when I look for information, I'm just, leery about this. But I would like the court to uphold my father's durable power of attorney, that we worked together for 33 years. It is just because our family made a plan, we followed through with that plan, and I am the result of it. Not only am I sitting on this end and did the work, I'm also litigating on behalf of my father and our agreements and saying no to what's happening and what's taking place right here in this court. And if I didn't do that, I wouldn't have the opportunity to be in front of the court and to go through the lengthy trial that we went through.
Thank you, sir. Another question for you.
Sure.
I know you were trying to explain this. It just wasn't registered yet, and so I want to revisit it. And that is this notion of it's undisputed that you're suing your father for millions of dollars in some other forum. And I think you were trying to explain to me, yes, Judge, I'm doing that, but I have to do that for some particular reason, and I didn't. That's the part I'm not understanding. So maybe you go back over that for me.
Before an idea of a conflict of interest came up, it didn't come into the play until a petition for my father's guardianship and conservatorship came up. Had I got to my father and we had to talk and he was in this state, I would have done everything that I can to make sure my father was getting the health care. He wouldn't have been in that hospital for 6 months. They did that. I didn't do that. And they, instead of trying to work with us, they just decided to rebel. We're going to do it our way because this is how we're going to do it. No one sat down.
But why does it mean you have to sue your dad? Why wouldn't you just sue Miss Fuller?
Well, because right now, I am suing Miss Fuller.
I know, but why wouldn't you? Why do you have to sue your dad? That's the part I'm trying to have you educate me.
Okay, let me educate you. Me and my father had an agreement. He breached the contract. Okay? He went and sold the property, did other things, regardless of under what circumstance. I haven't found all that. So as we go forward, I'm going to find out, and I'm finding out who did what. People took the property, they got their names on the property. There's not one property out of 7 that it just has my father's name on it.
So I just heard you say that I think this is helpful to me, thank you, that it's your belief, your allegation that your dad breached the contract, and that is the basis for your lawsuit in other forums.
that is one is called account stated, where basically we have an agreement of what was going to happen and the money, how the property was going to be transferred, etc. That's where the judge is going to rule on that. In the second case,
so the judge is going to rule whether or not your dad breached the contract that you had with him.
no, that's the complaint with everyone. The one we have that's just me and my father in front of the judge is called an account stated, where my dad understands we had an agreement. This is how it's going to be processed. This is how it's going to be paid, and somehow all that got messed up. And what the evidence is, the power of attorney, all of the agreements. We have the affidavits of work history. We have all the projects and my invoices that are, and also the child support payments that were made out of my father as far as deductions. That is that. And it's only because my father is not in control. He's incapacitated. So my understanding at the time was to be able to file it to stop everybody from doing everything with his property. Now that I'm understanding, my father, the durable power of attorney is upheld, it's an automatic delete that, because we can go after the perpetrators. We know who they are. At one time, I didn't know. I'm hearing hearsay. Now I know. These are the perpetrators. These are the people involved. Some of them came here in front of the court and gave testimony. Luca, Liberty, selling the property the same day. There's supposed to be a 3-day period in between. So it was set up. My sister having someone served and taking the other 50% of a house that my father and mother owned. And then Luca taking 3 of the properties for less than fair market value. And no one did any research on any of them. I did. I was sending them notices, information, and they mentioned they would get my letters, but they all want to decline it. Oh, I got the $3 million letter that you were messing with my property, and here's my demand for payment since you have the property. And if you don't give this up, that is the status of stating a claim upon which relief can be granted. It's not words. What did I do in the process? I sent them invoice. I sent them a letter for demanding payment. Neither of them respond. None of them. I even sent my sister the same letter. So my father's claim that I have is only because of Oregon advocates and what they've done by interfering with me and my father's agreement. Now, if this goes away, my father, it's an automatic dismissal. And I would do that gladly because my father, we and him can talk about what we need to do.
But you're asking another court to take a look at an agreement and decide if that court is going to uphold the agreement. Am I understanding you correctly?
Yes, only because this court, when I filed my letter for, I believe Mrs. Salisbury, it's called the Notice of a Disallowance of Claim in Full, that the federal court wrote a document, but they disallowed my claim for the 7.5, and the court was saying, the federal court, you can't be shopping around for a venue, you got to let this case dissolve here. But the real issue is the petition, is the guardianship being terminated. Me and my father can move back to step 1. He will not be included.
So I think I'm going to stop asking a question. This is going to be my last one about this, and then I think you're probably about done. You're asking another judge in another capacity, another courtroom, to determine whether or not there was a valid contract between you and your dad. Is that correct or not correct? Did I understand that correctly or not correct?
Yes, that was what the petition was about, to look at the evidence, because I was being denied here the opportunity to mediate. Everything was
so you're asking, I just want to make sure I'm understanding, you're asking another court to determine whether or not your dad breached a contract.
That's a part of it.
Okay,
Yes.
That answers my question. All right,
Yeah,
anything else you want me to know in your question?
Yes. Yes, because this court was not the venue or the jurisdiction to talk about the particular contract. I was told on its face value, this is not valid. I heard them today. This is not a real agreement. We're not going to honor this. We're not going to do anything else. So I had to still participate in the petition of terminating them so we can move forward. When I'm getting nothing here, I brought it to the court. It was turned down. So I let it go because I heard that this was not the venue from our experience. Like, this is just about the protective proceeding. It's not about what he owes you, etc. And because of the 14th Amendment due process violations of me and my father's agreement. He wasn't given an opportunity, neither was I. I filed a petition in federal court in order to make the ruling on that I have some type of judgment upholding that the assets are not a part of my father's estate. That's all I'm trying to prove. But now that my father's going to be with me, we can resolve this matter another way and keep the complaint just about the people that we know that violated him, Tinker Company, that forged his signatures, Luca, even dealing with Mrs. Wilkes and with Mr. Wisdom. If they're part of this fraud, if they're part of the what they've done to breach my father's stuff, and if they spent that money and took that $190,000 out my account, they're going to pay. There's no friendship when it comes to robbing my father. He was their friend. But if I find other, yes, I'm going to sue them to the maximum capacity, and hopefully in the racketeering part where I get 3 times the value of what I'm asking in my father. So we can leave and live happily ever after. He has no friends. There's nobody going to go visit him. He's just out there. He's alone, and he needs to be at home. He needs to be with me. That's just what we plan. He talks about it, man.
Mr. Willey, I think, I don't know if it's been an hour or so, but it's been a while, and there's a lot of repeating. I know I asked you some questions, and so I appreciate you indulging me.
Okay,
so I guess I'm just asking, how much more time do you think?
I just got a few minutes. I'm just going to wrap this up. I'm just saying we've got some professional misconduct, prejudicial administration of justice. We have some this is serious stuff to me, and it is serious to the bar as well as to the Judicial Commission. When you sneak behind someone's back and unevenly handed try to pursue a venue amongst a certain group of people when I'm not even there and can't defend it. And there's things that were happening. They've been getting these extensions and no one was there to say, I object. And they made a habit of it so much that they got caught, and they're putting other judges in a position, because judges, like I'm sure, come around, they're going to take the honor of an attorney. I see you enough, you seem to be reputable, but when it gets a judge in trouble because they didn't follow up, like Alec Horn said, hey, please, give them a copy of this July 29th hearing. It's right there on the order. It was never given to us, and we have 3 of them that were given to us. We have the original petition that wasn't served on me as his durable power of attorney. And the court has no jurisdiction of my father. He wasn't served either. And so these are some issues to me that this case should be thrown out. I should be able to move forward with my father on our durable power of attorney like we planned it. And all this hearsay from third-party people that he don't, my father loves me. If that's not the case, why was I there for 33 years? Why does he trust me? Why does he love me? I'm all he's really got. And he'll have a better life being with the family that loves him versus third-party people trying to control assets that don't officially all belong to my father. My father's not going to be left out in the cold. He's not going to be needing any food. We need to fix a few of those houses up. It was a part of our plan. But we had people coming in and interrupt. So I'm asking the court to uphold our durable power of attorney, which states that there is medical issues here and that the security interest is only because of the other agreements. So that if I didn't uphold that, yes, it's revocable. That's what was being said in this agreement. It's only revocable. It only could be revoked if I don't uphold my end of the deal. So it was like a two-way street. We had to both work with each other to move forward. But if I didn't do my work, he could revoke that. But if I did my work, he has to pay it. And he didn't pay it. I believe now it's not because he didn't want to. I think the dementia and the things kicked in, and like Lucas said, my dad needed money, he was told. And then everybody closed in him and took everything. And I have a way for us to get that back. So I'm just saying, I've asked the court to uphold our durable power of attorney. It's the less restrictive way. It was here first before anybody did anything. We've got proof of it. The document's been filed, and we live that type of life. I need my father. He's a part of my life. I want to see him in the last days happy. Where we can talk about all the things we've been through. And then go fix some of the properties. I don't mind he's in a wheelchair. I want to show up. Dad, we finally gonna get beach done. Because it took years, he didn't get a lot of stuff done. And I don't want my father to always feel like a failure and like he's left in some facility because no one stepped up to the game to take care of him. I would have took my father out of the hospital when this happened back in April on my birthday. I got interfered with. And that's what stopped me. And so it took this long to come in front of the court. So I asked the court to humbly honor our durable power of attorney, and we will dismiss the claims in another venue because there would be no reason for that. I have my father. That's what I want. My father, and he comes with me and the assets we worked and built together. That's not just his work. That's mine too. So that's what we asked the court today, to make that consideration and to revoke the Oregon Advocates LLC for not disclosing information in the petition when the courts would have known. Thank you.
Okay, thank you, Mr. Lee. All right, Ms. Wilkes, go ahead.
Thank you, Your Honor. I have known Mr. Martin 50 plus years. He's been a friend and family. And you mentioned a $195,000 balance. The courts have misled you on those and APS. His balance wasn't $195,000 when he was admitted to Good Sam Medical Center in December. And they basically have defamed my character and also violated my constitutional rights because I would never steal from Mr. Martin. Mr. Martin complained to the bank in August when he was over his own affairs that $50,000 was missing out of his account. They never investigated it. Mr. Martin had lived with his girlfriend for over 12 years, and she was spending the majority of his money, and we asked ASP to investigate that, and they never opened up a case. Mr. Martin's, his son never had a feud with him. The feud was with Mr. Martin's daughters. They always had something going on that was to their advantage. As a matter of fact, Mr. Martin shared with me that they even broke up the marriage. Mr. Martin was a nice, kind soul, hard worker, went to work every day, worked up until age 82, never filed for anything that he was eligible for at age 65. He continued to work. Mr. Martin felt as though he didn't have anyone, and he was a very independent man. And since Junior lived in Montana, Mr. Martin felt like he had really no one to depend on or to go downtown and defend his properties from red tagging and et cetera, et cetera. So unbeknownst to us, he chose Earl and I to be power of attorney. And he showed us those documents after the daughter had taken the house on 8th. He was furious, just furious about it. And I think that's when his health started declining, because he couldn't believe that that happened. And then we asked Adult Protection Service, again Megan Hoffman, to open up an investigation about Mr. Martin's $1.2 million on a commercial building that Tyco Title never opened up an escrow account on. And there were never any payments made, and Mr. Martin was looking forward for that money, for any care that he needed. There was never an investigation open. And there was never nothing ever mentioned of it again until Mr. Lucas was here on stand. And we learned a little bit more about how they swindled the property out of him. And Mr. Martin has a special way that he makes his G's. And on some of those documents, his signature was forged. Anyhow, they decided to circle the wagons around Earl and I, because they probably didn't feel like we was competent enough to come to court and testify exactly what went on. And Mr. Martin had left his girlfriend and did not go back after he left the nursing home. And Mr. Martin had nothing, not even a bed to sleep in. And if they would have reviewed, a lot of that money was spent on Mr. Martin and his care, because he had given $40,000 to Torian, another $20,000 to some other guy, and had no justification of why these people got this money. That was told to Megan Hoffman also, and she did not investigate. So Mr. Martin's account was not at $195,000 as you indicated when he was in the hospital, because he had to use those funds for food, shelter. There were certain medical supplies he needed because he had a UTI that the VA hospital did not follow up on. Mr. Martin was cooking his own breakfast, everything, when he left the nursing home. He had to hire caregivers because it kept declining. He didn't know what was wrong. They only gave him antibiotics once for his UTI. Never a follow-up appointment for another urinalysis. So it turned septic, and at Mr. Martin's age, when it goes septic, an elderly person can also get pneumonia from that. And that's basically what happened to Mr. Martin, and he was in Good Sam Hospital for 52 days, which they experimented on him while he was in there, because he went in for pneumonia and a UTPI. Those are corrected by intravenous IVs, and you're gone home. Not 52 days. And that's when his health declined drastically. He was still able to talk to us. We visited him on occasions, and he would ask for Junior. And he didn't know that Junior would come here from Montana to rescue him. But I'll start like this, father-son. Junior, when he was born, was named after his dad. Years later, Gregory would have him at the work site. He was so proud of him, and he wanted to teach him everything a father-son would teach a son. And he wanted to make sure that he was a better electrician than what he was. And Junior excelled all that, and Gregory was awfully proud of him. And what he told me, what I used to have breakfast with him every other morning. There wasn't a day went by that we did not communicate out of the 50 plus years. Mr. Martin was the electrician and the only one I would trust on my rental properties. And Mr. Martin never overbilled me. He was always honest with his price. I never bickered about his price because he was always honest and fair. He wanted Junior to be that type of person in his footsteps. And the type of pledge that Junior has presented to the court is basically a pledge that minorities do in their families, based on the fact most minorities, way back when Mr. Martin was a child and had grandparents and uncle, that's how they did things, because they didn't trust the courts, they didn't trust lawyers, so they would leave pledges and have them notarized. I knew this pledge was into effect because Mr. Martin mentioned it on several occasions, only he called it a living trust. That's the term he used. I don't have to do anything because my paperwork is already in order, is what he would tell me. And he was so proud of Junior. But he was right about it wasn't room enough for the both of them in this city because Mr. Martin knew everybody at Hoffman Construction, Colay's, Anderson's. So it was like a conflict for Junior to be in town bidding against his dad on electrical jobs. So Junior decided to venture out to Montana and start his own adventure. And he did an excellent job of it. Junior would occasionally communicate with the daughters, and that's how all these lies and rumors started. They told Junior that his dad was kidnapped, Don did, and that there were people stealing his money. That was not true. Mr. Martin at the time, when Don told him that in July of 2023, was handling his own affairs. We did not actually come into effect until February when he was discharged from Good Sam Hospital. Mr. Martin was handling his own affairs. When Junior called the Adult Protection Service to tell them that Don had told him, the very one that wanted her dad to pay for her husband's college education, and Mr. Martin told me, she must be crazy. She don't know the nature of a man. I'm not paying for her husband's college education. So Don proceeded to tell Junior that Mr. Martin was kidnapped, money was being stolen, so Adult Protection Service investigated. Unfounded. They investigated several times. They didn't tell you that, but if you check their records, you will see it was unfounded. And there wasn't a balance of $195,000 like they indicated because Mr. Martin was living off of that money. Mr. Martin was on insulin shots when he left the nursing home. He told me he didn't like those shots. He didn't like being poked in the stomach. I said, well, Gregory, all you have to do is change your diet.
Your Honor, at this point, I'm going to object any testimony for facts, not evidence. I'm not really interested in jumping up every time I hear that, but I just want to make a standing objection to any testimony, to any facts that are not evidence for the record.
Yeah, so just to remind you, Ms. Wilkes,
It's not.
so let me just.
Go ahead, Your Honor.
Let me just. As I said earlier, this can be hard. Closing argument is based upon whatever evidence is in the record and arguments that flow therefrom, reasonable inferences to be made. It's not a time to talk about, if the record talks about how the weather was, we don't get to a closing argument, talk about what color the car was. And so that's what he's saying is that, hey, we talked a lot about the weather, but now you're telling us about what Grandma cooked on Tuesday night. So, and I think what I'm going to say is the standing objection remains. It's a bench trial, not a jury trial. I recall the evidence in this case, so I'm only going to consider the evidence that I recall that was properly admitted in this case.
I understand.
So, go ahead.
I'm just leading up to why Junior should have full custody of his father. Because they're father-son, he can make sure he has the quality of life, and he's already shown that by just being responsible for the short period of time he's had to get all these documents and everything together and still take care of his family. Gregory does not have that much time left. So they need to have the father-son relationship. Gregory's 82, be 83 in February. They need to have that quality time together. And Mr. Junior's record does not show he's unfit to take care of his father. And what he don't know, I'm sure he will learn. And he will take very good care of his father. So with that, I'm requesting that the court take into consideration of the pledge that was there and what was understood in 1993 and what was supposed to happen when Mr. Martin became fully incapacitated, and let them be father and son for Mr. Martin's last days. That it might prolong his life to 104. His mom lived to be 104. But him stuck in a nursing home with strangers is just going to deteriorate him. And he's going to be unhappy. And he didn't have a relationship with his daughters anyway here. He's always had that bond with Junior. And I've always known that the 50 plus years that I've known Mr. Martin. And that's all I have to say, Your Honor.
Okay, thank you, Ms. Monks. All right, so again, because the petitioner filed the case, they get to go last. It's called rebuttal close. Ms. Salisbury, go ahead.
Thank you, Your Honor. Just a few things. It's been stated that in the closing arguments for others that, I think incorrectly stated, so I want to correct it for the record. Ms. Fuller was never removed from the Clackamas case of this year. So under the ORS 125.240, the only thing you have to give notice of are bankruptcies and removals, which is why that's what's included. So it wasn't an attempt to obscure evidence or hide information. That wasn't required. Additionally, it's been stated a lot that notice provisions were not done under ORS 125.60060. However, all notices have been provided in this case. When the notices prior to some of the emergency hearings were waived by the court due to immediate and severe danger to Mr. Martin, and a notice was sent out after, as required in 125.605. So all the notices have been sent out. Everything that's been required has been followed. Just because someone is allegedly a power of attorney does not indicate that they have to have personal service. The only one that gets personally served is the protected person. Everybody else gets mail service. And that's been completed. In fact, we serve people that didn't even request notice. We have continued to serve them throughout this case just to over-notice people of what's going on. So I wanted to kind of lay that out. You had asked a question about the pledge agreement. What happens if he were just to pass away? All of the assets were in Mr. Martin's name until they were moved around to different places. None have ever been in Mr. Wellhead's name. And so what it would have been is it would have been a claim against his estate. And at that point, he could have presented a claim and presented an argument saying, hey, I completed a pledge agreement and here's all my evidence. And somebody else would then would look at it and say, yes, did you do everything you were supposed to do? Did you meet the terms of the pledge agreement? Is it valid? And then the court would make a decision. We're still in that fact pattern. Even if he were to terminate the federal case against Mr. Martin, we still need somebody to represent Mr. Martin and say, did he do everything under the pledge agreement that's required? Did he do all those things? To really vet out whether or not those things are correct. Right now, it's just, well, I said I've done it, and that's good enough. And that hasn't been determined yet, and Mr. Martin is not in a position at this moment to be able to do it himself. He needs to have somebody who doesn't have a horse in this race to say, hey, was it valid? Is it not valid? And that's exactly why professional fiduciaries are often used in those situations, because the outcome to them doesn't necessarily matter. They're there to say, hey, does this make sense? Does this not make sense? Let's present an argument that represents the protected person's best interests, and to review what is allowed or not allowed under the law. There's other things that Mr. Waleed did, and he's filed a $33 million UCC claim against everybody, including his father. That was done prior to the beginning of all this. So there's still that issue that has to be dealt with. And again, if he's power of attorney, he's not going to be acting in the best interest of his father, because those are two competing positions. And then he said in the power of attorney, it states that he has the ability to make medical decisions, does not. States he has access to medical information. So decisions are made by a guardian. Access to medical information or bills or those kind of things are something a conservator is able to do, because they have to be able to pay the bills and say whether or not that bill's valid. It's not being able to make a medical decision. So the guardianship is still required even if the power of attorney is held up. So at this point, we would like to renew our request that the petition be granted, my clients be granted as the indefinite guardian conservator. And I would like to say, them being appointed grants access to all of the children to be able to have a relationship with their father, or for him to choose to have a relationship with them. So there is no barrier when it comes to that situation. So just to mention that. Thank you, Your Honor.
Okay. Okay. It is 3:55. I'm going to take some time to review my notes from the several days of hearing, as well as all of the exhibits presented, review applicable case law and statutes, and take some time to make my decision here. We set aside the entire day tomorrow, just in case we needed to finish trial. So my plan is to give a decision at 2 p.m. tomorrow. The parties are welcome to appear by phone. I realize you're from Eugene. I don't know if you want to go back to Montana tonight, probably not, but you can be here in person or on the phone. I'm giving you that option. So if you're choosing to appear by phone, check with my clerk before you leave to make sure you have the WebEx information. I won't be able to see you, but you'll just be up on the screen and I'll have your name. But 2 o'clock tomorrow will be the decision. And with that, we can go off the record, and each of you have a good night. Take care.
Thank you.
Thank you, Your Honor.